Before we start this video, please make sure that you're still subscribed to the channel because YouTube keeps unsubscribing you guys, and I don't know why they're doing that.
Go ahead and do the YouTubey things.
I would love to be sued, seriously. I mean, I wouldn't love, I mean, I'm not saying like sue me, but like imagine the discovery.
This thing has gone completely out of control.
It's like a train off the rails into a dumpster fire in a crater from an asteroid.
This is ridiculous. We have long since passed any idea of normalcy or reality.
Y'all. Speechless.
I'm not gonna go broke. I'm not gonna lose my channel. I'm not gonna file for bankruptcy. Like, just stop.
Now, maybe if you had been staying off social media in general and not talking about your case like to the world, that would have been helpful.
Do not talk about the case.
Does anyone remember the personal jurisdiction issue? It seems so far away. I'm looking on the horizon. I don't think I can see it anymore.
Say it with me. Jurisdiction.
Brown and Saltz are now at a pissing match against each other.
Am I missing something?
Oh man, yeah, we need a little kumbaya here between these two. That's what really needs to happen at this point.
By the way, I don't have stock accounts. I don't have fake accounts. I don't have time for that.
Thankfully, I have multiple Twitter accounts, so you'll have to find me again.
Hey you guys, welcome back to my channel. Started B. Tati's lawyer, Michael Saltz, has filed plaintiff's response to defendant's motion for status conference. In this filing, he also included a declaration of his own, a declaration of Eleanor R. Levine, who, as per my understanding, is somebody on his legal team, as well as a declaration from Natalie Kennett, who is a former subscriber from Katie's channel. And this filing, you guys, got pretty ugly.
All the shit has, like, it's out of the horse. It hit the fan, it got picked up by a tornado, then a tsunami, and it's fucking everywhere like a pipe explosion.
And because there's so much in this filing, I decided to split the video into 2, maybe 3 parts.
There are a lot of documents here.
This first part, we're gonna look at the motion itself and Michael Saltz's declaration. But before we start, do not forget to go down below and subscribe to the channel and ring that bell button so you can get notified every time I post. Also, as a quick disclaimer, I just want to remind you guys that everything we discuss here in the channel is my opinion, and my opinion only, not to be taken as a fact. Always do additional research from the information that you get here in the channel. Do not send any hate to the people that I'm going to be talking about in this video.
Am I right, fellow adult?
However, I do encourage all of you to go in the comment section and let me know what do you think about the situation. Earlier this month, Michael Brown has filed a defendant's request for status conference. And if you don't know what that is, here's a definition. It's a meeting of the judge and the lawyers or unrepresented parties in a pending legal matter to determine how the case is progressing. At the status conference, the judge may ask about what discovery has been conducted, whether and how the parties have tried to settle the case, and other retrial matters. And as most of us already know, they are going to be speaking with the judge early February. Just to catch you up on everything that's going on, let's have Emily D. Baker explain what's going on so far in this lawsuit.
The suit was filed. There were motions to not delete your shit. That was resolved by stipulation. Then there was a motion to dismiss, generally on the grounds of jurisdiction. That motion still has not been resolved yet. A motion for status conference was filed by the defense. The defense saying, Your Honor, pull this lawsuit over. We need to have a chitty chat. The judge issued a minute order, which is a short order from the court saying, okay, this is the briefing schedule. Plaintiffs need to file a response for the request for status conference by yesterday at like midnight. And then the defense has to file a response by Friday. That's where we're at.
So now that we know where we are at, let's go ahead and take a look at the first 2 documents for this video. Up first, we have the plaintiff's response to defendant's motion for status conference. While defendant's motion for status conference, quote-unquote, motion, fails to comply with this court's standing order for all civil cases, plaintiffs do not dispute that a status conference with this court is necessary. On a little footnote down below, Saltz says that the defendants failed to make meaningful efforts to confer before filing the motion as described in more detail below. Him saying that defendants failed to comply with this court's standing order is because Brown did not try to talk to Saltz and get this resolved before filing. However, if this court considered defendants informal request to quote-unquote place restraints on counsel's public behavior, plaintiffs respectfully request an opportunity to submit additional briefing as defendants have failed to establish that an order forbidding plaintiff's counsel's speech is warranted. Additionally, if a quote-unquote gag order is issued, it must be against all participants in this case, including defendants. Just for a little bit of context here, Michael Brown on his motion takes a lot of shots at Michael Saltz by accusing him of quote-unquote social media litigation and also taking advantage of the situation by using Twitter to gain followers and fame. But we all seen what Michael Saltz is doing. He's just trying to get witnesses and win his case. But I think that Michael Brown is using the notoriety that Michael Saltz has been gaining, the adoration of everyone who's watching so closely this lawsuit. He's trying to spin it into Michael Saltz is trying to be famous. But I do love that in the end of the day, Michael Saltz said, well, if I can't do it, neither can the defendants. Plaintiffs also seek to address defendants' misrepresentation of their motion. At no point as plaintiffs' counsel Michael Saltz publicly accused Ms. Wilson of hacking into his Twitter and Gmail account. Notably, defendants have not submitted any evidence of such public accusation because none exist. If you need more context about that, I have a video where I read the entire Michael Brown's motion and declaration, so you can go ahead and watch that. I have a playlist for Without a Crystal Ball's case that I'm gonna leave by the end of this video and down below. But yes, in Michael Brown's motion and declaration, he alludes to the fact that Michael Saltz was accusing KJ of hacking him. Finally, plaintiffs agree that the court intervention is appropriate at this time, but disagree that it is due to the actions of plaintiffs' counsel. Defendants, not plaintiffs' counsel, are attempting to litigate their case on social media. Since the filing of this case on October 30th, 2020, defendants have published or made dozens of unprovoked, prejudicial public statements regarding this case on various social media platforms, including but not limited to YouTube, Twitter, Facebook, and Instagram. Plaintiffs' counsel has used social media to investigate this case, seek out witnesses and evidence, and on occasion refute defendants' prejudicial public statements. Since plaintiffs' lawsuit was filed less than 3 months ago, defendants have had dozens of public statements regarding this case on Twitter, Facebook, Instagram, and YouTube. Below is a non-exhaustive list of times on which defendants addressed this case on social media. Then he listed most, if not all, of the videos and tweets that KJ has posted since the whole lawsuit started, which I don't think it's all of them because she keeps deleting stuff, so.
Let me show you what we're responding to, Your Honor. Here's a fucking list.
As this case involves defamatory statements asserted on social media, plaintiffs' counsel Michael Saltz has used his personal Twitter account to seek out witnesses and information relating to the plaintiff's claims and to refute defendants' numerous unprovoked prejudicial public statements about this litigation. In mid-January 2021, Mr. Saltz and several of plaintiffs' witnesses were subjected to widespread hacking of their personal social media and email accounts, as well as vicious online harassment, including doxing. On the morning of January 18, 2021, a federal holiday, Mr. Saltz alerted Mr. Brown to the urgent hacking issue and requested a telephone call to discuss the matter. The two exchanged several emails, but no telephone conference occurred, nor Mr. Brown request one prior to filing defendant's motion. On this part, Saltz addresses again the fact that Brown did not try to talk to him on the phone before filing his motion.
Before you bring your shit to me, y'all need to talk about it.
Then he has on quotes here, which I assume is something from the standing order, saying that the parties should provide at least 3 business days between attempts to confer and a motion's filing, and shall explain their specific efforts to comply if contact was not successfully made. Motions that do not comply may be summarily denied.
Piping hot fucking tea?
In one of Mr. Brown's emails, on January 18, 2021, he stated, quote, "I am skeptical about your allegations, but they should be aired in front of the judge. I also have concerns that I want addressed. I don't think we can get her attention on a holiday, but perhaps we should send an email. or something today, end quote. No attempt was made by Mr. Brown to substantially discuss the matter. Defendant's motion was filed with the court at 5:53 p.m. that same day. And I know that I got this one wrong on the first video. I thought they were talking about KJ, but now plenty of you made me aware of the fact that they were talking about the judge. Any constraints on the plaintiff's counsel use of social media are unwarranted. I had to read this title because of the footnote. It says, curiously, defendant's request for this court assistance to restrain plaintiff's counsel from quote-unquote litigating plaintiff's case largely on social media directly contradicts defendant's position that this court has no jurisdiction over this matter, as set forth in their pending motion to dismiss. Oh my god, this was so funny. When I read it, it's like, yeah, I think on civil law mentioned that. It doesn't really make sense that they've been filing all of these things when they believe that this court does not hold jurisdiction. So what are they doing?
Help me, I'm getting dumber by the second.
Defendants failed to establish how Mr. Saltz limited statements to his relatively small group of followers on Twitter have somehow created a quote-unquote massive social media circus surrounding this lawsuit. Defendants acknowledge that plaintiff Tati Westbrook is a quote-unquote prominent social media personality. Additionally, Ms. Paulson has over 2,000 more Twitter followers than Mr. Saltz and has a YouTube channel with more than 135,000 subscribers. Ms. Paulson has continued to address this case to her followers on both Twitter and YouTube, among other social media venues, since plaintiff's complaint was filed. Moreover, the filings in this case are publicly available and closely followed by parties, thousands of supporters and detractors. Additionally, defendants have failed to identify any statute, rule, or case law that prohibits counsel from seeking witnesses and information relating to the plaintiff's defamation case on social media. In fact, the Washington Rules of Professional Conduct expressly permit counsel to publicly discuss a case if the statements will not have a quote-unquote substantial likelihood of materially prejudicing adjudicative proceeding in the matter. Specifically, counsel may state inter alias, quote-unquote, a request for assistance in obtaining evidence and information necessary thereto, and quote-unquote, warning of danger concerning the behavior of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. Further, counsel may make a statement that a reasonable lawyer would believe is required to protect a client from a substantial, undue, prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Mr. Saltz's inquiries and statements on Twitter related to the case are limited to seek witnesses and information, warning of danger about the widespread hacking and harassment of witnesses, counsel, and parties to this case, and clarifying defendants' misinterpretation and or statements made on social media after the complaint was filed. None of Mr. Saltz's limited public statements have a substantial likelihood of materially prejudicing this matter. If anything, Mr. Saltz has been trying to clarify defendants' unprovoked prejudicial statements against plaintiffs. Moreover, plaintiffs' counsel never publicly accused defendants of hacking or threatening defendants or defendants' counsel with criminal prosecution. Plaintiffs' counsel actually informed Mr. Brown that widespread hacking of his personal social media and email accounts, as well vicious online harassment of witnesses and hacking of witnesses' social media and email accounts was occurring, and that a forensic expert had been engaged to track down the hackers who were making serious criminal threats. So far, I agree with everything he's saying. I did not see him accusing her of anything. He does have a sassy way to his tweets, but he knows what he's doing when he says things, and so far it all checks. This part, he goes back to say that if the court decides that he should not be talking on social media about the case, that the same kind of restraint order should be extended to the defendants and Mr. Brown. And then he moves on to talk about Mr. Brown's declaration and requests to strike it. He claims that the statements about the referred screenshots and emails were misleading and irrelevant. He uses an example from the motion in quotes, "Below is a screenshot from a video on a YouTube channel that Mr. Saltz has promoted on his Twitter account." And as an exhibit, he used a screenshot from Emily D. Baker's video and not Saltz's Twitter promoting her, which, in my opinion, I agree with him. It makes this completely irrelevant. On his second example, he says, in quote, "Below are screenshots of just a few of the tweets Mr. Saltz has posted to publicly accuse Ms. Paulson of the crime of hacking." And then Saltz proceeds to say that none of those tweets says that he recognizes her as the hacker, but he recognizes her email on the hacking attempts, and he also does not name her on his tweet comments as the hacker. The next example is, quote, "Attached in exhibits A through C are the true correct copies of emails Mr. Saltz sent to me this morning accusing Ms. Paulson of federal crimes and demanding that I explain my involvement," end quote. On this one, he's referring to one of the emails that he told Mr. Brown that the hacker came out to him and told him that he was doing it for KJ, and he asked Mr. Brown to preserve all evidence that they may have. And then he concluded saying that he does agree that the court should get involved, but however, he does not agree that the court should get involved because of the plaintiff's behavior, but the defendant's behavior. And that was golden because he had a whole lot to show. And it doesn't stop yet.
Is a whole nother level.
Let's go ahead and jump into Michael Saltz's declaration. He introduces himself and makes known to the court that he is also allowed to practice in the state of Washington. And he go ahead and say, "I have a personal Twitter account that I have used to investigate the facts in this case and to obtain public assistance in the collection of evidence and information. To be certain, because a significant portion of the statements at the issue in this case were public to a specific and specialized audience on Twitter, I have gone on to Twitter to both collect evidence of said statements and identify potential witnesses and other information to help prove the elements of our claims or to better understand the evidence that is being provided to us by hundreds of informants and potential witnesses. To the extent that I have commented on this case on the Twitter account, it has been within the ambit of the rule. Some tweets have been to specifically respond to Ms. Paulson's numerous unprovoked prejudicial statements. For example, shortly after the complaint was filed, I was informed that Ms. Paulson made an unprovoked prejudicial statement about this case on her YouTube channel that was directly contradictory to a previous statement she made. In response, I tweeted." So on his tweet, he says, "I haven't seen it yet, but did KJ just do a live stream unprovoked by my client, hearing she talked about the case and said to the public she was not biased in reporting on my clients, in direct contradiction of her October 30th post saying she was biased in reporting my clients?" And then the tweet that he's talking about is right below, where she says, "P.S. I was biased about Tati because I've done months of research on this story and her husband is a damn fraud. You shouldn't want frauds in the community, my opinion." Somebody responded to his tweet saying, "You've been correctly informed." I looked for the footage, couldn't find it, but if I do, I will post it here. KJ blocked my Twitter account shortly after my clients filed their lawsuit. Otherwise, my tweets that are related to the case have been limited to the investigation of this matter in progress and requests for assistance in obtaining evidence and information necessary on this matter. For example, he posted tweets of him asking people who have stopped buying Halo products because of KJ's videos, and he got answers from people on that subject. He goes on to say, "None of my public statements will have a substantial likelihood of materially prejudicing this case. It's my belief that defendants are, through these proceedings, attempting to inhibit our ability to perform our investigation of this matter and seek the public's assistance."
Saltzy played the Uno reverse.
He also explains that the information he got through Twitter would be impossible to get through other means, and also doing it this way was very cost effective for his clients. He also goes on to say that currently KJ has 8,430 followers on Twitter and approximately 135,000 subscribers on YouTube. He mentions that in the beginning of November 2020, after the filing of the lawsuit, he was monitoring Twitter and YouTube for information regarding monitoring KJ's activities on social media. And by doing that, he observed a number of people on Twitter and a number of YouTube creators who were publishing negative criticism about KJ or publicizing that their social media accounts were getting hacked. He also noted that in November he had 3 unauthorized attempts of login to his Instagram account, noting that he has had this account for a number of years and this kind of situation have never happened before. He also notes that when that happened to his account was around the same time that KJ's detractors' social media accounts were also potentially under attack by hackers. And then he goes on to say, on or about January 7, 2021, I was alerted to a particular series of tweets from a Twitter account that I recognize as belonging to KJ. I learned that said tweet was a part of a series of postings KJ was potentially posting containing public statements about this lawsuit and containing particular threats and insults directed at myself and plaintiff's witnesses. Given the benefit of reviewing said tweets after recent events, it is my observation that one of those tweets appears to contain a possible admission by Ms. Paulson that she is a benefactor of my law firm's email account potentially being hacked. The tweet in question states, "Email communications go both ways. Trust me, just like I'm being watched, so are you. We know everything." He also mentions that on or about January 7th, he personally viewed a video live stream from KJ titled "The Worst Day Ever." And he observed in the live stream that KJ was telling her subscribers to go after detractors to defend her and to let her know who the detractors are, so she can, quote, put them on blast. They're not going to mess with you. We'll take care of it, end quote.
Don't feel like just because you defend me that they can make an example out of you, because we'll make an example out of them. Don't be quiet. Don't be shy. I always used to say, like, don't feel like you have to defend me. But now I'm saying, like, if you're seeing this bullshit and you feel compelled, you can defend me. I have your back. You're not going to get harassed. And if you do, you just send me a DM and you tell me, and I'll put them on blast. They're not going to mess with you. We'll take care of it.
He also uses an example, another part of the video, quoting,
"The vintage Katie is back. I am not placating. I'm not going to pretend to be less me. I'm not going to listen to my YouTube manager and be like, you should do things that don't upset your audience." Dude, everything I do upsets my audience. Like, no. Well, are there topics that you can avoid? Anyways, don't feel bad about defending me. Defend me. Go for it. Have fun. Like, don't feel like just because you defend me that they can make an example out of you, because we'll make an example out of them. We will. We'll prove to everyone what they're doing to you guys. Don't be quiet. Don't be shy. Speak your truth. I always used to say, like, don't feel like you have to defend me. But now I'm saying, like, if you're seeing this bullshit and you feel compelled, you can defend me. You can. You can speak out against bullying. You can. You can tell the trolls to go away. You can tell them they're not welcome. The reason why they are so invested here is because they feel like they can and that you guys aren't going to respond because I've told you not to, and they've manipulated that and they have pounced on that. So I just say, I have your back. You're not going to get harassed. And if you do, you just send me a DM and you tell me, and I'll put them on blast. They're not going to mess with you. We'll take care of it.
After that, he starts introducing all the events that happened in January with the massive harassing and hacking campaign that was unleashed by KJ's fans against YouTube creators, Salty, and some of the witnesses. And he exemplifies this by making note of the declaration of Natalie Kennett, which we will be covering in another video. The next page, he posts some screenshots of his Twitter showing the attempt hacks on his account and what he said about it. As shown in the Google verification code notice above, it states that my email address was being added as a recovery email address for Miss KJ email account. This means that at the Google notice being legitimate, I would have been able to click on a link and sign into Miss KJ's email account and archive all of her emails. However, because illegally hacking into a party's email is something I would never do, I investigated the notice and determined that the Google notice was a fake phishing notice. I determined that had I clicked any of the links, my email account credentials would have been hacked. My tweet above did not directly accuse Ms. KJ of being the source of this hacking attempt. When there's a phishing link on somebody's inbox, if you click the link, whoever sent you that phishing link will get a reply with information about your time zone, your location, what is the electronic source that you are using to click that link. So if you are on a computer, on a laptop, on a cell phone, will give the country location and you will give the IP of that particular internet access that you are using when you click the phishing link. Starting on January 16, 2021, I personally observed and documented the harassment and threats that were being made against Ms. KJ's perceived detractors, including the threats being made against me and my family and other YouTube creators. And I can attest to what happened on Twitter and elsewhere after Ms. KJ aforementioned statement is far more extensive and disturbing than that of which has been portrayed in Ms. Kennett's declaration. In this next part, he mentions about the threats he's been receiving as well as the plans of the hackers to try to frame him as a and also another hacker who made an account called @Hannah233303 who used his youngest daughter's picture as their avatar, and they sent him a very intimidating message. And that particular tweet says, "Life is very lonely without a family, and what a beautiful family you have. A wife and 2 young impressionable daughters. You as a lawyer are not untouchable. May I suggest you therefore leave Miss KJ alone from this constant harassment before harm comes to anyone." The same account proceeded to send him a DM with more threats. You have 24 hours to render yourself not the opposing counsel or your family will face the consequences of your actions and behavior. Don't make me regret giving you this chance. We have seen your emails and know all witnesses' names, addresses, emails, and numbers. It is not in your best interest, Mr. Saltz, to take this case any further. Ms. KJ has requested that as of 8:51 a.m. you have 24 hours. Next, he mentions that throughout the filing of the declaration, he have received information that multiple YouTube channel creators who have published critical videos about Ms. Folsom have experienced social media accounts hacked. They have received harassing emails. They also have received death threats, as well as experiencing mass flaggings on YouTube and Instagram. Before we move on, I just want to give you guys a trigger warning. We're now going to speak about a child's illness and the mother's grieving about the loss of a child. So if that's a subject that will trigger you, I would tell you to stop watching this video. No hard feelings. But if you don't have a problem with that, let's keep going. He also mentions how the hackers have been targeting former paid members from Washington of Ms. KJ. In this part, he describes the event that happened with one of KJ's paid members who was in one of KJ's lives, and Katie asks if anyone have ever taken their child to a trauma center. This individual said that she did. People in the chat asked her if her child was okay. She proceeded to tell the people that her child passed at age 10 from cancer, and people started giving her condolences. However, Ms. Folsom started getting upset that the chat started giving attention to this specific individual, and she called out this individual.
And you're in this hospital and you guys is chatting about it's really weird to me that you guys are sitting here chatting about things that are totally unrelated, and I'm telling you something really serious, and you guys are just talking about things that are unrelated. I actually think I'm gonna go. It's weird to be opening up and all I see is you guys sitting there talking about yourselves. You guys are being really rude. It's weird. I was gonna turn chat off. I honestly can't imagine sitting here and having someone open up to you about the hardest day of their lives, and you're sitting there talking to strangers and you're literally just not even listening and you're just talking about yourself. And now the chat is focusing on Susan and Debbie. I understand that you're talking about what happened to you, but when you're chatting and I'm talking, how do you listen to me? It seems kind of rude to me. You're sharing with me while I'm talking. I can't read with you and you're talking and then it's taking over the entire chat. All I see is people talking about their own stuff, and it's weird. I've gotten used to this weird thing about when you live in this world, because it's you say to turn chat off, but you're not trying to share with me. If you're trying to talk about your own life while I'm talking, you're not actually listening. I don't think that makes sense, but whatever. It's distracting when I'm trying to tell you a story when I see the chat and you guys are talking and you're not listening, and I'm having a hard day. When one person opens up, then everyone else has to pile their stories on and talk about their life too. And sometimes all you want is someone to listen and not have to tell you about what they went through. You just want someone to hear what you said and to understand and to not make it about themselves. When I'm in the middle of telling you something extremely traumatic that happened to me, I highly doubt you would start talking about your own child and make it about you because you can empathize. We as parents start competing in a way with one another that, like, our experience was worse.
After this incident, the subscriber posted on Twitter, "Thank you, I'm so happy I unsubscribed to both her channels. I was a paying sub from Washington until that day. I should remind her of that." Mr. Saltz also shows a tweet where one of the hackers came after this specific subscriber. The subscriber posts a tweet directed to KJ saying, "This is my daughter, the one you called out for when I was showing you empathy about what you went through. Hug your son, celebrate that he's still here." And the hacker subtweet saying, "Poor you. Katie wasn't even calling you out. She apologized. Can't you just get over it?" And I want to be fair here. I think that what Katie did was very shitty. But a lot of people were speculating that what Chloe said was for her to get over the passing of her child. However, I don't think that that's what they meant. I think that they meant to get over the fact that Katie treated her like trash on the live, which I also don't agree with. Especially when you're dealing with your subscribers, your paying members, people that support you and want to be there for you. They don't deserve to be treated that way. These people that subscribe to your channel and that interact with you, they are a blessing. No creator is entitled to subscribers. If you have subscribers in your channel, those people want to support you. The least you can do for them is to hear their stories and be nice. Because in the end of the day, yeah, they're there to support you, but they want to connect with you. And I don't think Katie understands that. He also mentions next that this kind of behavior from these hackers, AJ supporters, is making people who are willing to cooperate and testify being afraid of coming forward. He also mentions that one of the hackers came to him to let him know that they were acting under KJ's direction. And they also claim that she has 2 Gmail accounts and 24 Twitter accounts.
By the way, I don't have sock accounts. I don't have fake accounts. I don't have time for that.
Thankfully, I have multiple Twitter accounts, so.
All right, back to the paperwork. I'm sorry, KJ had me and Manny use a certain IP address to sign into so that this wouldn't come back to her. She also gave us email/passwords. We can provide proof, but not on here. Please accept my apologies. KJ gave others information and told them what to do. Another account just tried to come forward before she regained the account to make up she'd been the victim. This evening, I will be taking all necessary screenshots and sending them to the relevant agencies. Out of concern for the safety and well-being of our witnesses, at 8:21 a.m. PST on January 18, 2020, I emailed Mr. Brown to advise him of the intimidation of our witnesses and massive hacking of the accounts of individuals released to this case. I requested a phone call with Mr. Brown to discuss the situation. Mr. Brown never responded to my requests for a call. This is the email he's referring to where he sent to Brown the concerns where one of his witnesses has been receiving threats because they refused to delete some tweets. I read this email in another video that I'm gonna link here, or you can also pause and read the email now. He also refers to all of the other email communication he has had with Mr. Brown in January 18, 2021 and attached on Exhibit 1. Let's go through the emails. This first email is from Michael Brown to Saltz showing a potential client inquiry for Michael J. Saltz from Find Law, and on the email it says, "I want to make a formal complaint of harassment against your lawyer Michael Saltz. He's intimidating me as a witness in the Tati Westbrook case, and if he doesn't stop, I will file charges against him." Michael Brown wrote on the body of his email saying, "Katie did not make this complaint. The phone number is not hers." This next email is from Michael Saltz to Michael Brown saying, "Michael, you should be aware that the hacker just stated on Twitter that he/she was hired by your client to do what they did. You should check the account before it is deleted. Suffice it to say, very serious claims have now been made implicating your client in these and other matters. We ask that you take all steps to preserve any and all evidence so that a full forensic investigation. We also demand that you document and take control over the 24 Twitter accounts and 3 email accounts that apparently belong to your client to safeguard them from deletion due to the quote-unquote sock accounts now being exposed. Please confirm that you have done so, that such evidence can be preserved pursuant to the court's order. We wait your response." On this next email, Michael Saltz says to Mr. Brown, "The other hackers disclosing information of your client's plans to delete evidence and bring false charges against me. They claim that your clients gave them a special IP address and passwords to do their work on their behalf. Part of that was to sign myself up with various sites and then make police reports against me claiming that I am a pedophile. Hackers claim to be 13 and 15 years old and were hired by your clients through Facebook. They claim that this was done to discredit me so that I could not prosecute the case. They also claim that your client was fabricating evidence to make a claim that we were harassing her. They also claim that they were told to try to hack into your client's account to make it look like she was being hacked too, so she could pretend to be a victim. There is evidence of open communication and planning between your clients and the hackers' accounts, as all involved foreshadowed that they were going to hit us with a big surprise. We demand to know what your involvement or knowledge was of these alleged plans. Be advised that we are immediately sending a subpoena to Twitter to obtain the full identity of these now admitted hackers that your client reportedly hired. I assume under the circumstances you will not be objecting. Be advised that the hackers claim to have documented all interactions with your clients. I love that he says yours truly in the end. Brown responds by saying, we need to get the court involved ASAP. Katie denies all allegations, and I certainly know nothing about any hacking or the other stuff. I do know that Katie is under a barrage of people attempting to link her Google account to people she does not know. It would be the least surprising thing in the world if it turns out that one of your thousands of quote-unquote followers is setting her up. I'm skeptical about your allegations, but they should be aired in front of the judge. I also have concerns that I want addressed. I don't think we can get her attention on a holiday, but perhaps we should send an email or something today. Saltz also sent screenshots of Chloe's messages to the witness saying, you really thought I'd let you get away with being a witness for Salty?
Oh, fans of the channel, fantastic.
Today I hacked you all via a very special VPN and hacking tools linked to your IP address. That's right. If you continue as a witness, we will prove you responsible even though you are not. You will end up sued and face 45 years in jail. Your choice, sweetheart. Email me back and we can sort this out. Show this to anyone and you will find yourself in a wooden box in the ground. He also sent screenshots of public tweets from Chloe, and if you want to read them, please pause and do so. Saltz mentioned that Brown has never tried to talk to him about the situation and just went ahead and filed the defendant's request for status conference, and the only way Saltz found out about that filing was because he was electronically notified of it. Saltz also mentioned that he has contacted the FBI and the Los Angeles Police Department to conduct an investigation about the harassment, the hacking attempts, and all of the threats him and his family have been receiving. Saltz also notifies the court that there has been an internal investigation to assess the source and the extent of the hacking attempts, and he will notify the court when this investigation is completed. And this is basically it for Saltz's declaration and the initial paperwork. I will make another video on the other two declarations, but I just want to remind you guys, please don't get involved in the situation. This has already gotten way out of hand. Let's just air out our frustrations and opinions in the comment section here on my channel and on Twitter or any other channel you would like to watch, but just don't get involved. And just a quick update on that proposed alternative to file records under seal. There was a minute order that the court declined to review the unfiled material in camera. They did say if the attorneys wanted to address their concerns, they should be filing a joint motion to seal that includes a stipulation that in the event the material do not meet the criteria for sealing under local rule, the documents be withdrawn rather than publicly filed. And we do know by now that there is a joint filing, and we're gonna get to that. I know I'm pretty late, but we will get to that. Go ahead in the comment section, you guys, and let me know what you think about all of this. The hacking and the filings. What is your opinion? And if you like this video, please don't forget to drop a like. Go ahead and subscribe to the channel now and ring the bell button so you can get notified every time I post. Also follow me on my socials. They will be down in the description below. Thank you so much for watching. I'll see you in the next upload.